in Parliament, though. Honorable Inusah Fuseini, former Tamale Central Member of Parliament on the ticket of the NDC. Hello, good evening, sir. Welcome to Eyewitness News. I'm curious to know what your own views on the impasse has been since we started hearing or seeing it.
Well, thank you for having me. The own view is that this is a needless rising of tension by the office of the president, consequent upon the letter that was written by his executive secretary to the clerk of parliament.
I see, but the speaker feels that the domain of parliament is being encroached upon, and he thinks that he has to assert what we may call parliamentary, not supremacy, but independence. And so he finds it an affront that the president will treat matters that parliament has transmitted to him in the manner the president did.
The speaker is obviously concerned with the apparent unconstitutional acts of the president in the way he's treated bills passed by parliament. The things that the combined effect of that is to lower the parliament in the estimation of the Ghanaian people and weaken the institution of parliament. As head of the institution, he has a responsibility to ensure that the dignity and sanctity of the institution is maintained. The speaker's recent action is a vivid demonstration of the absurdity of the decision of the presidency to reject the letter, the transmittal of the bill passed by parliament to his office.
People think that all that you've said notwithstanding, the president erred on the basis for which he, should I say, adjourned parliament without considering the president's nominees. He said in equal measure he was unable to deal with the approval of the ministers and deputies because there was a pending injunction application before the Supreme Court, when indeed and factually at the time of the statement that application hadn't come to the notice of the Supreme Court.
I've just told you that when the matters outside the respective domains of the arms of government are brought into being or are made to influence the performance of the functions of the various arms of government, it leads to this level of absurdity. And that's what we are seeing. The president alluded to the writs filed at the Supreme Court, challenging the constitutionality of the human sexual values and sexual rights and family values bill. Now, and consequent upon the presence of those writs in the Supreme Court, the president felt he was incapacitated in sending his signature to the bills or refusing to do so. Now, the president, instead of allowing the processes that has been spelled out in the Constitution to go his full hog, the president, through his executive secretary, truncated the process. That caused the ire of Parliament. Parliament was deeply troubled by that action. And that's why they took the action. And so, clearly, the two actions by Dr. Odoy and Mr. Sky have not been pronounced upon by the Supreme Court. So there is no binding judicial decision on that matter on the president. The suit of the Joseph Moko has not been pronounced upon by the Supreme Court. So there is no binding judicial decision on the Speaker. Mr. President decides that in the absence of a binding judicial pronouncement in these two writs, he is going to flout the express provisions of Article 106.7 and 106.8 and refuse to accept the transmission of a bill that has been passed by Parliament. Mind you, the enacting formula for any law in Ghana is bills passed by Parliament and assented to by the president. So this duality of rules must come into being before we can say an enactment has been born. The president truncated the process. He did not take advantage of the 7 days contained in Article 1067. Neither did he take advantage of the 14 days contained in Article 1068, and so refused to take advantage of the 30 days contained in Article 90 if the bill were referred to the Council of State. Cumulatively, the president chose to ignore the 51 days window given him by the Constitution to deal with a situation as exists today. How do you expect Parliament to react to such a development?
I see. Just to pick your view, because you're an experienced member of the House, is it out of order for the secretary to the president to communicate a matter like this in the way he did from the presidency to Parliament? Is that normal? Is that out of order?
Well, the secretary also in communicating did not communicate to the speaker, but communicated to the clerk and said it was for the attention of Cyril K.O. in Sia. So I think the secretary knew that he was treading on dangerous ground. That was why he wrote to the clerk and not to the speaker.
Others have said that the president did not want to be in contempt by going ahead to work on the bill because of the application. Indeed, I heard you say that there was no binding decision of the court on the president or the speaker. But the law, as we have come to see it, is that once an injunction application is pending, that operates as a stay until the application is dealt with by the court. Of course, there's another view, but this view I've just espoused is becoming or has become the dominant view.
The dominant view is for the persons to respect the court and to ensure that they do not do anything that will prejudice the outcome of their cases or cause irreparable damage or harm when the case is decided one way or the other. But that is within civil law. That is within parties. That is not constitutional. A constitution is sui generis. It is not any basic law. It is the ground norm. All basic laws take their source from the Constitution. So the standard in abdicating rights between parties is different and ought to be different from the standard to be used in adjudging or engaging compliance with provisions of the Constitution. That's what we should understand first. Two, even though the provision or the principle of law does seem to suggest that when actions are filed in court, those actions must operate to stay any further development between parties on the matters litigated. That view springs most largely from the British judicial authorities. Britain has no written constitution. Even though our courts, and let me hasten to add, even though our courts have followed those decisions because they have been persuasive, but Britain has no written constitution. Ours is a democracy that has got a written constitution, which constitution has established institutions and organs of state and vested those organs with powers and instituted substantive, procedural, and institutional limitations on the exercise of those powers. They are two different things. I agree that that might be the dominant view. But as a person, a student of constitutional law, I believe that the standard in adjudicating cases involving the Constitution must definitely be different from that. And especially where the Constitution imposes a responsibility on a person, an institution. Can we lawfully say that if that person is carrying out that responsibility in accordance with the procedure provided by the same Constitution, that person or institution can be injuncted from performing that duty? Is it reasonable? Does that sound logical? Will it be sound law? In any case, don't you think that even if the court comes to the conclusion that Parliament ought to be injuncted, that the Speaker ought to be injuncted, that would be tantamount to an amendment of the Constitution?
I see. Quite interesting. Interesting days ahead, and we eagerly await what the Supreme Court, the law lords at the Supreme Court, have to say about this. Thank you so much, the Honorable Inusah Fuseini, for speaking to us on Eyewitness News. Eyewitness News on 97.3 Citi FM. A number of your messages here.